Further hearing in the appeal, Zipvit Ltd against Commissioners for Majesty's Revenue and Customs.
Good morning, Mr. Brzezinski.
Good morning, my Lord.
We will rise for a very short break at 11:30, just for a few minutes. Thank you very much.
Can I start by just identifying the stage we've got to in the analysis? We know that to succeed on the first issue, Zipvit has to establish that VAT has either been paid already or is due to be paid within the meaning of Article 168A.
Yeah.
At the moment, what I'm dealing with is the question of whether VAT has been paid already as part of the sum of money paid by Zipvit to Royal Mail at the time of the supplies, even though at the time of the supplies the parties agreed that the contract was exclusive of VAT, and even though their understanding was that there was no VAT to pay because it was an exempt supply. The only authority which my learned friend relies upon from the Court of Justice to support the argument that VAT has already been paid, included within the amount of money paid at the time of the supply, was Tulica. This is one and only authority, and for the reasons I've already given you, arising out of what the court said in paragraph 37 of that case, in our submission, Tulica does not provide support for that conclusion. But of course, he relies upon domestic case law and Section 36 of the VAT Act, and I'll come on to deal with that at the end when I deal with the domestic case law. But far more relevant to the EU law question are two recent Court of Justice decisions in Volkswagen and BioSafe, which are referred to in the Court of Appeal's judgment, on which there was extensive written submissions post-hearing below, but upon which my learned friend's written case is silent and his oral submissions are silent. I assume he's keeping his powder dry until reply. Can I start with Volkswagen? But both cases, as you will see, are relevant to the due or paid issue and the invoice issue. They're divided within a few weeks of each other. Volkswagen appears in primary authority's final tab 36. The court's judgment is at MS 1157. Before I take you to any part of the text, and because it's the first time you've looked at it, I assume, can I just give you a summary of what the case was about and what our key submission is on it? The facts of the case were that Volkswagen had for many years been receiving supplies of lamp mouldings from the lamp moulding supplier Hellas. At the time of the supplies, both parties thought that VAT was not chargeable, and so no VAT was charged. When the parties realised their mistake, Hellas issued Volkswagen with VAT-only invoices, and Hellas then paid the VAT to the Slovak fiscal authority. Volkswagen then claimed input tax deductions. The Slovak analogue of HMRC allowed some of the input tax deductions, but disputed the balance on the basis that they were out of time under a domestic limitation period. And it said, i.e. the Slovak fiscal authority said, that in applying the limitation period, time began to run from the date of the original supply. So that was the Slovak government's argument. And the question was whether that was right. The Advocate General's opinion and the court's decision was that that was not right. That was not in accordance with the directive, because Volkswagen's right to deduct the input tax did not arise and could not be exercised until the parties had corrected their mistake and Volkswagen had received the right VAT invoices from Hellas. Our submission is it would be completely inconsistent with the analysis of both the Advocate General and the Court to suggest, as Zipvit does in our case, that the original price paid by Volkswagen to Hellas should be regarded as having included VAT at the appropriate rate. If that had been the position, then the substantive right to deduct the VAT would have arisen at the time of the supply, VAT would have been embedded, and time would have begun to run from that point. Can I start, please, with the Advocate General's opinion? It's at MS 1163, internal 304. You may, in the fullness of time, wish to read it all, but can I pick it up, please, at MS 1173, internal 314. If we start at the top of the page, underlying this model being the whole VAT model, is the principle ensured by the common system of VAT that the taxation of all economic activities, whatever their purpose or results, provided that they are themselves subject to VAT, should be fiscally neutral. Under this system, the rules on deductions are meant to relieve the trader entirely of the burden of VAT due or paid. Thus, the payment of the tax to the supplier by the taxable person lies at the heart of the right to deduct. It's not possible to separate deduction from payment of tax. If the taxable person hasn't paid the tax, which generally appears in the invoice, there is no legal or financial basis on which to exercise the right of deduction. In the Principal VAT Directive, particularly Article 167, the legislature is referring to normal circumstances in which the supply of goods, the payment and the issuing of the invoice showing the amount of VAT all happen simultaneously. In that case, it makes sense that the chargeability of the VAT and the right of deduction arise at the same time. By contrast, a situation such as the one in the main proceedings can be seen as exceptional or unusual from the perspective of the VAT chargeable because A, when Volkswagen received the goods from the supplier, it did not pay any VAT. Not, I interpolate, it paid VAT embedded within the amount agreed in the contract. Since both parties believed that the transaction was not subject to VAT, I interpolate, even though we now know it was. And similarly, Volkswagen didn't receive an invoice inclusive of VAT, which would have enabled it to exercise its right of deduction. In these circumstances, the taxable person obviously could not claim the right to deduct an amount of VAT which had not previously been paid. There was a major change in the situation when in 2010 the Hellas suppliers made an adjustment in relation to the transactions which they had incorrectly thought weren't subject to VAT by collecting the amount of VAT owed by VW and paying it to the Treasury. From that point, I think that it would have been correct to link chargeability and the subsequent right of deduction with the actual payment of tax. In other words, what took place was, in effect, an example of late payment of VAT, I beg your pardon. With the adjustment of the transactions, the substantive and formal conditions triggering the right of deduction were truly satisfied. It was at that point that the calculation of a time limit for exercising it should have started. There was a genuine supply of goods, VAT of a certain amount became due and was paid to the Treasury, and the relevant invoice meeting the requirements of Article 226 was issued. As I said before, these paragraphs, particularly paragraphs 66 and 67, are inconsistent with the conclusion that the original price charged at the time of the supply included VAT. So in Volkswagen, as in our case, both parties wrongly believe that no VAT was chargeable. When it turns out this is wrong, the Advocate General's answer, and as I'll show you the court's answer, was not to say that input tax could have been deducted at the time of the supplies. Can I then turn, please, to the court's judgment? And rather than read out the whole passage that's relevant, because it will be somewhat boring, could I ask you now, please, to read paragraphs 37 through to 50, which is at MS 1161 to 1162, internal 302 to 303. So that's, again, paragraphs 37 to 50, and I'll make my statement. So just picking it up, please, at paragraph 49. In the present case, it's apparent from the order for reference that even though the supply of goods at issue was carried out during 2004 to 2010, the Hellas company suppliers didn't make an adjustment of the VAT until 2010 when they drew up the invoices, including the VAT, sent supplementary tax returns to the competent national authority for the amount of VAT that was due to the state treasury. It's equally apparent that the risk of tax evasion or non-payment of VAT had been excluded. In these circumstances, it was objectively impossible for VW to exercise its right to a refund before this adjustment, as prior to that it had neither been in possession of the invoices nor aware that that was due. Indeed, it was only following that adjustment that the substantive and formal conditions giving rise to a right to deduct VAT were met, and that VW could therefore request to be relieved of the VAT burden due or paid in accordance with the directive and the principle of fiscal neutrality. So in our submission, 4 points are clear from the passages you have just read. One, perhaps obviously, that the court said that compliance with the due or paid requirement in Article 168 is a substantive condition before the right to deduction can arise. 2, that until the parties took steps to correct their mistake in 2010, after which Hellas issued VAT invoices and VW actually paid the VAT to Hellas, neither the substantive nor the formal conditions for an input tax deduction had been met. 3, the reason that the substantive condition had not been met was that until that point, VAT was not due or paid. And so there was no basis on which Volkswagen could request to be relieved of any VAT burden. They had not suffered any VAT burden.
Is that consistent with the last bit of paragraph 49, where they say that Volkswagen couldn't exercise its right to a refund, as prior to that it had neither been in possession of the invoices nor aware that the VAT was due?
Well, aware in the sense that until, and we'll see this from other case law, my lord, until you get a VAT invoice, there's nothing that makes you due to pay the VAT. You might know from a decision of a fiscal authority or a court that the supply has become or is chargeable, but as I'll develop in my later submissions, the directive distinguishes between whether a supply is chargeable and whether you are due to pay.
But how is that compatible with Tulica? I thought in Tulica it was due and payable even though no VAT invoice had been presented.
I'll come back to that question, but I don't think that's what the court said. What the court said was that in circumstances where it is open to the supplier to exercise a right to claim an additional amount of VAT on top, then you can't regard VAT as having been included in the original amount paid.
Right.
Do we know whether there was any consideration during argument of the, what you might call, VAT embedded in the earlier payment concept, which is
in these cases?
Yes.
We don't, my lord, and Mr. Thomas's point in writing below was to echo what my lord has just said, to say, well, it wasn't raised explicitly in argument. But in my respectful submission, whether it was raised in argument or not, it would be completely inconsistent with the court's analysis to say that Volkswagen's substantive right to deduct tax had arisen and could have been exercised from as early as 2004 on the basis of some embedded VAT. Indeed, if that was the case, what the court would have said in paragraph 50 is it's only after delivery of the invoice that the formal conditions have been satisfied. But they plainly regarded that the substantive conditions hadn't been satisfied until then. And I took you to the passage in the Advocate General's opinion where he said it wasn't until that point that VAT had been paid. So it isn't as if they weren't alive to that point. Can I then please turn to the BioSafe decision, tab 21. Just to give you the chronology, unfortunately, the printouts in this bundle, some of the cases, the dates of the decision. So just to give you the chronology, Volkswagen is decided by the court on the 21st of March 2018. BioSafe is decided by the court on the 12th of April 2018.
And I'm so sorry, I missed the tab reference.
BioSafe is at tab 21. So, as is obvious from the relative contemporaneity of the two decisions, they were both proceeding through the court at around the same time. Indeed, all of the judges that decided BioSafe had also been in the Volkswagen case a few weeks earlier. Biosafe was a smaller court, but was a subset of the judges in Volkswagen.
Different advocates general. The advocates general were
Different advocates general. I'm going to say something about Advocate General Cockott in particular shortly.
Thank you.
So the case of Biosafe, what were the facts? The reference to the court arose not in the course of a dispute between a taxpayer and the fiscal authority, but rather, as sometimes happens, in the course of a dispute, a civil dispute in Portugal between the supplier of rubber granules, Biosafe, and its customer, Flexipiso. I'm going to call it Flex. At the time of the supply, Biosafe...
And just the customer was presumably a trader, VAT.
Yes, they're both taxable traders.
Yeah.
At the time of the supply, Biosafe, the supplier, wrongly charged Flex, its customer, 5%, i.e. 5% VAT. The Portuguese fiscal authority later determined that that was the wrong rate and that 21% VAT should have been charged, and they assessed Biosafe, the supplier, to an assessment for the differential. Biosafe then claims that differential from Flex, but Flex refuses to pay, saying that it, Flex, was now out of time under Portuguese domestic law to deduct the correct amount of input tax. So you can see the analogy, the similarity with this case and the Volkswagen case. And again, the question referred to the court was similar. Was Flex right about how the limitation period worked? Could it be prevented by the Portuguese VAT limitation from claiming the correct amount of tax? And that entailed considering when Flex's right to deduct could first have been exercised, to which the answer was, like in Volkswagen, only once the mistake had been corrected by Biosafe claiming the difference from Flex and delivering the right VAT invoice. Can we start, please, with Advocate General Cockott's opinion? It's at MS 909, internal 50. Could I just ask you to read paragraphs 1 to 4?
I'm so sorry, can I have the page number again?
Yeah, MS 909, internal 50.
Thank you. So you can see from that brief introduction that this opinion is going to be, as the court's decision, relevant to both the due or paid issue and the invoice issue. For the moment, I'm just going to focus on those parts of Advocate General Cockott's opinion which are relevant to the first issue. Could you turn, please, to page 911, internal 52. Again, paragraphs 11 to 15 briefly set out the relevant facts.
I hope I've fairly paraphrased them already. And then, critically, could you turn, please, to paragraphs 22 to 25 of her opinion, MS 913, internal 54. Under the heading towards the middle of the page, the first question, content of the question referred. By its first question, the referring court expressly wishes to ascertain whether the time period for the purchaser to be able to deduct the additional tax is calculated from the day of issue of the initial invoices, the 5% incorrect invoices, and not from the date of issue or receipt of the rectifying documents. The referring court's purpose in asking that question, contrary to what the Commission and the Portuguese submissions indicate, is not to determine whether the 4-year time limit laid down in national law is appropriate. Rather, it seeks clarification as to whether the right to deduct input VAT in the full amount arises as soon as the transaction is carried out, in this case in 2008, even where the parties have wrongly assumed that a lower VAT charge would apply, neither of them factored a higher rate into the price or showed one on the invoice. There are only two conceivable possibilities here. Either input tax is deducted at the objectively correct rate, irrespective of what the parties imagined would be applicable and irrespective of the rate shown on the corresponding invoice. That's Mr. Thomas's case. In that event, it would have been deducted in 2008 in this instance. Or the amount of the input VAT deduction is limited by the VAT amount actually shown on a corresponding invoice. In that event, input VAT would have been deducted in 2008 in relation to the 5% rate, but not until 2012 in relation to the difference. I consider the second proposition to be correct, so she considers Mr. Thomas' case to be wrong. For in my view, a distinction must be drawn between the accrual of the right to deduct in principle, see points 26 and following, of her opinion, and the accrual of the right to deduct in a given amount. Again, in due course, you may wish to read all of 26 to 43, but can I pick it up, please, at paragraph 44?
Page.
MS 916. MS 916. Internal 57. Paragraph 44. She says, I should like to draw attention here to the concept of VAT relief. It follows from this, as AG Campos Sanchez Bordona has recently submitted in the Volkswagen case, that's the footnote, that a deduction of input tax is possible only if the recipient of the supply sustains a charge to VAT. The latter, however, does not sustain a charge immediately upon supply of the goods or services, but only upon payment of the consideration, and the VAT contained within that consideration on the basis of an invoice showing the amount of VAT due. So just to answer my Lord Briggs's question earlier, was Mr. Thomas's case about embedded input tax raised in argument? The answer that one can see from the two possibilities identified by Advocate General Cockott in paragraph 24 is effectively yes. Advocate General Cockott and hence the court were fully alive to both those possibilities. Just picking it up then at paragraph 45. So have I read all of 44? Yeah. This is readily apparent even from the court's earlier case law, in which it was still explicitly stating that the immediate right to deduct is based on the assumption that in principle taxable persons don't make payment and therefore don't pay input VAT until they've received an invoice or another document which may be considered to serve as an invoice, and that VAT can't be regarded as chargeable before it's been paid. After all, the extent to which the recipient of the supply sustains or will sustain a charge to VAT is apparent only if VAT in that amount was included in the calculation of the consideration payable by the recipient. Where VAT was included in the consideration, however, whether VAT was included in the consideration is apparent only from the legal relationship underlying that consideration, i.e. the contract, and the billing for performance under that relationship, that is to say, the invoice. In the absence of such an arrangement, i.e. a contract that says it's VAT inclusive, and in the absence of an invoice based on that arrangement, the recipient of the supply can and will not pay VAT to the supplier. Not the recipient of the supply will have already paid VAT to the supplier at the lower rate. This also explains, as Advocate General Campos Sanchez Bodona rightly notes, the provisions in Article 178 of the directive linking the exercise of the right to deduct to possession of a corresponding invoice. If the supplier, as here, has not included the statutory rate of tax in his price and has not passed on that rate of tax to the recipient of the supply through the consideration agreed, which it had not yet done in 2008, same as our case, the recipient of the supply will not sustain a charge to VAT in that amount. Until he does, a deduction of input VAT would not eliminate a charge to tax, but promote one. It could not be clearer. I'll come back, as I said before, to other parts of this opinion later. Then turning, please, to the
I'm
court.
sorry, what does she mean by but only promote one?
It's exemplified or illustrated in her next sentence. He might at some point apply a deduction of input tax, which the supplier, being unaware of the higher rate of VAT because it hasn't received an invoice, would be entirely unable to pass on.
Oh, I see. Thank you.
Can we look, please, at the court's judgment? It starts at MS 904, internal 45.
Just before we do, none of this affects the liability of the supplier, as I understand, to pay VAT at the higher rate.
Well, the liability, whether a supplier has a liability to pay VAT at all or at any particular rate, will depend upon one of a number of actions being taken by the fiscal authority. It doesn't arise ex hypothesi just because there is a chargeable supply. Of course, normally speaking, when the fiscal authority knows that a supply of goods or services is chargeable, it will take steps to recover the VAT by issuing a VAT assessment, etc. I hope that answers my Lord's question.
Well, I think it does. I think you're saying that the fact that the supplier hasn't issued a VAT invoice claiming the appropriate VAT from the trader,
Yes.
in no way stops the taxman recovering the VAT from the supplier.
That is correct.
So that,
but
if
the
you like, the
converse-
person, the fall guy in all this is the supplier.
But the converse of that, my Lord, is that as soon as the supplier does issue a VAT invoice, and this will be made clear in the later case that I'm going to take you to, pursuant to Article 203 of the directive, that supplier becomes liable to pay VAT. The very action of issuing a VAT invoice exposes the supplier to a VAT liability to the state.
But are you saying he's not liable to do so if he just makes a supply and doesn't send a VAT invoice?
Well, if he makes a supply, doesn't send a VAT invoice, and the fiscal authority doesn't assess him, as they ordinarily will do
But I mean, an assessment is something for which one assumes the person is liable.
Yes.
Otherwise, it'll be successfully challenged.
Yes.
So
But-
why does the assessment make any difference to the analysis?
Because until the fiscal authority takes some action to create a debt between it and the supplier, as a matter of law, and this is what Judge Mosdale rightly identified in paragraph 137 of her judgment in this case, as a matter of law, there is no debt between the fiscal authority and the supplier. It's true that the supply is chargeable, and I'll develop the difference between the two in a little while.
So you say, so the answer to my question is the failure to send a VAT invoice to the trader
Yes.
doesn't in any way affect the
Chargeability.
extent to which the supplier is chargeable, but the liability and debt will await an assessment.
Exactly so.
And I suppose you say what's happened in these circumstances is because of the legitimate expectation created by HMRC vis-à-vis Royal Mail they've been blocked from
That's one of the things that I do say, yes, and I'll be developing that, yes.
This elevates the invoice to quite a significant position in the transaction. I noticed in the Advocate General's opinion that it was talked about as triggering the charge. I don't think that's exactly the word, but it's in paragraphs 44 to 40.
And that's because of Article 203.
Yes, I see.
I'm just going to get you the reference to Article 203. I'm pretty sure it's in the primary authorities bundle. Tab is it 16? If my lady looks, please, or the court looks, at tab 17 of the primary authorities bundle, MS 895, internal 36. Article 203, VAT shall be payable by any person who enters the VAT on an invoice. So that's the trigger created by the issuing of a VAT invoice.
And then there's things said in the opinion in the Volkswagen case about the impact of that on the, not the supplier, but the next in the chain.
Yes.
And their obligation to...
Can I come,
yes, come back to
can I come back to that, my lady? Can I just look for the time being briefly at the court's judgment? We're in tab 21. As I said before, all the judges, I'm going to mispronounce their names and I'm sorry, Rosas, Loda and Yarasinas were in the Volkswagen case, and it's therefore unsurprising that the format and content of this judgment is strikingly similar to what it was in the prior case. Indeed, all the way from paragraphs 27 on MS 907, internal 48, all the way through to paragraph 38 are effectively identical to what they have already said in Volkswagen. And indeed, at every stage, at every paragraph, they quote back from Volkswagen. Paragraphs 39 to 41 on MS 908, internal 49, we can pass by swiftly because they refer to the Portuguese government's case-specific argument that the contracting parties, Biosafe and Flex, had been engaging in tax evasion, to which the Court of Justice said, well, you can try that in the national court, it's not for us to work out. And then paragraphs 42 and 43 come back to the core reasoning that has already been seen in the Volkswagen case. So 42, in those circumstances, it seems that it was objectively impossible for Flex to exercise its right to deduct before the VAT adjustment carried out by Biosafe, since before it didn't possess the documents rectifying the initial invoices and didn't know that additional VAT was due. Indeed, it's only following that adjustment that the substantive and formal conditions giving right to arise to deduct VAT was met, and that Flex could therefore request to be relieved of the VAT burden due or paid in accordance with the VAT directive. So until that point, there was no VAT burden due or paid. Can I now say something about the analysis of or the weight to be given to the opinions of the Advocate General? As I've already noted, Mr. Thomas says none of this matters, the court didn't grapple with the issue. I say he's wrong about that. I think he would also say that you don't have to take into account, or at least you certainly don't have to follow, the opinion of the Advocate General. Opinions of the Advocate General, I'm sorry this is basic stuff, are obviously not binding upon the Court of Justice or this court. Nonetheless, in our submission, it is important to recall that in formal terms, advocates general are officially members of the court's judiciary. They are judges. And their views are to be accorded respect. And in our submission, that is particularly so where an advocate general has been closely involved in the development of the court's jurisprudence in one particular area, as Advocate General Cockott has been in the area of VAT. I don't suppose any of that is particularly controversial, but we spent some time looking for some helpful statement of what the status is of Advocate General opinions, and the best place to find it is in the case I handed up and put onto the bench this morning. It's in the Court of Appeal in the FII litigation, or at least one stage of the FII litigation.
One of very many stages.
One of very many stages. and in the interests of trees, I have not printed out even the whole of the Court of Appeal's judgment. I've just printed out the head note, probably irrelevantly. Can I ask you please to look at page 1294 of the Simons Tax Cases report, in the judgment of Lady Justice Arden as she then was. Right at the top of the page, in the first line, you can see the judge referring to the opinion of Advocate General Bott in a case called Scatter-Vaquette. Lots of cases are called Scatter-Vaquette, but this was one of them. And the rest of that page, until letter H, is talking about the Advocate General's opinion in that case. And then at the bottom of the page, 66, paragraph 66, that analysis, i.e. A.G. Bott's analysis, is precisely the one for which the claimants contend. Mr. Ewart, counsel for the Crown, submitted that it was simply incorrect. The Court of Justice in Scatter-Vaquette didn't in any event need to address the point, since it considered that Article 56 didn't apply on the facts for reasons unconnected with the AG's analysis. Moreover, it is established community jurisprudence, and this is the bit that I'd ask you to sideline, that where the ECJ remains silent on an issue considered by the AG because the ECJ disposes of the case on different grounds, the AG's opinion stands as legal authority in its own right. See Takis Tridimas, the role of the Advocate General in the development of community law, some reflections. It is not in any way binding, but may prove useful in a future case where the same issue falls to be examined by the Court of Justice, and, I say, by a domestic court. So I hope that is helpful. In this litigation, Lord Justice Henderson said at paragraph 80 that neither Biosafe nor Volkswagen threw any useful light on the due or paid issue. With respect, we disagree. They do. So, just pausing to identify where we are on the analysis. Those are the key cases on the question of whether Zipvit can be said already to have paid the VAT back at the time of these supplies. We say Tulica doesn't support that conclusion for the reasons I've already taken you to, and Volkswagen and Biosafe directly contradict it. And that's all I want to say for the time being on the paid point.
Could you just give me the paragraph in Lord Justice Henderson's judgment?
80.
80?
80.
Thank you.
Before I turn to the due bit, can I just identify one other principle that I flagged up in my rather long-winded summary in opening yesterday? And it's, you can give it the shorthand, no asymmetrical reliance. Or put slightly more fully, it's the principle that you can't both benefit from an exemption under national law and then also claim an input tax deduction. And authority for that principle is found in many cases of the Court of Justice. The one I'm going to take you to is called MDDP, Additional Authorities, Volume 2, tab 37.
Is this the supplemental bundle of authorities?
No, we've got the primary,
Non-primary.
volumes 1 and 2 in the blue covers of additional.
Well, I'm on screens. Is it
Oh,
in the
I'm so
original?
sorry.
Is it in the original?
It's MS 1498.
Oh, it's in the
will
original
be,
one.
yes.
That's fine.
Yeah, it's not in anything handed in the last couple of days or a few days.
No, that's fine. I've got it.
MDDP was a case about a Polish company of that name which supplied educational training for accountants and other professionals in return for profit. Polish national law on its face exempted all supplies of education, rather like it was understood in our case that English national or UK national law exempted all supplies of postal services. But because MDDP wanted to be able to claim an input tax credit on its own purchases, it sought a ruling from the domestic authorities that its activities should be treated as taxable rather than exempt. Two questions were referred by the National Court. The first was the equivalent of the TNT question in our case, i.e., what was the scope of the exemption for education services permitted under the principle, that directive, and was the Polish national exemption compatible with it? And on that question, not directly relevant for us, the court held that the exemption from VAT in Polish national law was, when taken at least at its widest, wider than, and thus contrary to, Article 132, sub 1 of the directive. That's the analogue of the TNT decision. The second question referred by the National Court is the one that's more relevant for our purposes. And the question is as follows. If a taxpayer supplier has had the benefit of an exemption in national law, and then that exemption is later declared by the court to be inconsistent with the directive, so our case, can it then also take the benefit of saying that its supplies should have been treated as standard rated so as to get an input tax credit? And the answer given by both Advocate General Cocotte and the court was no. Could I take you please first to the Advocate General opinion, MS 1502, well, that's where it starts, internal 325, and just identify the question at paragraph 3 on internal 325. The other question, which concerns the consequences of incorrect exercise of discretion enjoyed by a member state in determining the organisations exempt from tax, has even wider implications. In particular, it has to be clarified here whether a taxable person may rely subsequently on a tax liability for its transactions required by EU law, which is what Zipvit is doing, in order to be able to deduct input tax without being subject to an obligation for retrospective taxation of its transactions, which it previously treated as tax-free, according to the provisions of national law. And her answer can be found at page MS 1508, internal 331, paragraphs 37 to 38. Paragraph 37. By the second question, the referring court is inquiring whether in circumstances where a national exemption is incompatible with the VAT directive, according to Article 168, a taxable person is entitled both to take advantage of the exemption and to exercise the right to deduct input tax. In my opinion, in the first VDP dental laboratory case, on which judgment had not yet come out, but she's referring to her own opinion, I expressed the view that an asymmetrical reliance on the sixth directive isn't possible. A taxable person could not both rely on the directive, which doesn't provide for tax exemption for certain transactions, in order to be able to deduct input tax, and at the same time take advantage of the tax exemption under national law, which is contrary to EU law. That would be inconsistent with the central principle of the VAT system that input tax can essentially be deducted only on the taxed output transactions. It's true that MDDP concerned a supplier, but these are general statements of principle, and they are then addressed by the court in its judgment. I won't take you to the answer to the first question, the scope of the educational exemption. The second question is addressed by the court in its judgment at paragraphs 40, critically through, for our purposes, through to 45, MS 1519, internal 342. Just picking it up, please, at the top of the page on MS 1520, internal 343. First of all, it should be noted that as the Portuguese and Polish governments and the UK government observed, it's a central principle of the VAT system that the right to deduct VAT levied on the purchase of input goods or services presupposes that the expenditure incurred in acquiring them was a component of the cost of the output transaction that gave rise to the right to deduct. It's apparent from the introductory part of Article 168 of the VAT Directive, which lays down the requirements for the origin and scope of the right to deduct, that only operations subject to input tax may give rise to the right to deduct the VAT levied on the purchase of goods and services used to perform those operations. Consequently, according to the logic of the system established by the VAT Directive, the deduction of taxes, of input taxes, is linked to the collection of output taxes. A statement of principle concerning fiscal neutrality, which is very difficult, if not impossible, to reconcile with Mr. Thomas's case. And then paragraph 45, it follows from the foregoing that even where an exemption provided for by national law is incompatible with the directive, Article 168 does not permit a taxable person both to benefit from that exemption and to exercise the right to deduct tax. And at the risk of repeating myself, that is what Zipvit is trying to do in our case.
Is it trying to do that? Because if it's saying, go on, if you ask me for the tax, I'll have to pay it, then it's not.
My lady, I'll come on to deal with that, but the whole, I know this is something that my Lord Sales took up with me yesterday, but there is not a shred of suggestion, either in the appellant's written case or in the claimant's case in their action against Royal Mail, the civil action, which I'm going to have to take you to, that what they're asking for is to be subjected to a demand to pay additional tax. And there'd be no point in them doing that. It's a question that my Lord Hodge raised right at the start of the hearing yesterday with my learned friend. There'd be no point in them doing that, because what they receive with one hand, they'll have to pay back with the other, or vice versa.
Yes, but they may be asking in the expectation that it would never be required, that they would pay the sum.
They've never, but my lady, they have never asked.
No, I understand that, but it's just what is seeking to rely on an exemption. That's
well, they're seeking to rely on an exemption in our case, or rather, they're seeking to rely on a standard rated position in our case. Yet at the time, they relied upon what was understood to be the national exemption because they didn't pay any VAT. And that's the analysis that the court would give, as is apparent from...
Well, that assumes, in your favour, that the tax already paid argument is wrong.
Yes, and that's why I was careful to distinguish what stage in the analysis I had got to.
Yes.
Tulica, Volkswagen and Biosafe are about paid. I'm in an interim stage between due and paid where the two concepts are linked, and I'm going to, in a minute, come on to the due bit, which I hope will answer my lady's question in slightly fuller terms.
In this case, the UK case that we're considering, you're not claiming that the wording of the UK statute gave an exemption, are you? Are you claiming that
No,
you misconstrued,
the
revenue misconstrued it?
We tried unsuccessfully in the first tier tribunal to say that you couldn't read the postal exemption as it on its face was set out in national law, compatibly, notwithstanding the muscular mar leasing obligation, with the way in which the analogous exemption in the principal VAT directive had been interpreted by the...
Yes.
And the FTT rejected that, and we have not appealed that.
No. I wanted to be quite clear. That's
Yes.
just
Not
how
resigning
far we're
from that
parallel between MDDP. Thank you.
Yeah. Just to give you a couple of other references. The first is to VDP Dental. I'm not going to ask you to look at it, but I only refer to it because Advocate General Pocock mentioned it.
Just before you, can I just pursue another point with you? The asymmetry, if the tax has been paid, arises at Royal Mail's level, doesn't it? I mean, if the assumption is
Yes.
that the tax is embedded in what Zipvit paid Royal Mail, it would be, the asymmetry point might be an answer which the revenue could deploy in face of any attempt by Royal Mail to resist having to pass it on to the revenue.
My Lord, that would be right analytically. And if the tax is embedded in what's already been paid, I lose on the first issue, but and I'll develop my submissions, I'll still win on the second issue.
Well, yeah.
But yes, my Lord is right. So, again, just to give you the reference, I'm not going to take you to it. A few months after the MDDP case, there was the VDP Dental case. I'll give you the references to where they say the same thing. It's Additional Authorities, Volume 2, Tab 48, paragraphs 38 to 39, MS number 1715. What I will do, out of respect for this court, is to take you briefly to where that principle was endorsed by this court in the Investment Trust Companies case. I'm going to come back in a little more detail to the ITC case that my Lord Hodge may remember later on. It's in the second supplementary bundle. If you've got the same colour scheme as I have, it's in the one thin cone-bound volume with white on the front rather than blue on the front.
Does this have a memory stick?
I'm afraid it doesn't.
Right.
It's been sent to you electronically. It just doesn't
good.
have any useful MS numbers on it.
Well, I may nonetheless... Oh, I see. Well, I may nonetheless have it.
I'm not at the moment going to take up time even telling you in broad terms what this case is about. I'll come back to that description later on, if I may. Can I just, for now, take you, please, to one passage in the judgment of Lord Reid, with whom everybody else agreed. It's paragraph 29, appeal cases, page 292.
You haven't got a page number? I have.
Which
I have electronic page numbers because it's come
49?
across as...
Do you have
49, okay.
49 electronically.
Thank you.
Yeah.
Yep.
So Lord Reid here is referring to the Becker and VDP Dental case, and just picking it up, please, just above letter D, sentence starts 2/3 of the way across the line. It follows from these authorities that the managers, that's the suppliers, could not both claim reimbursement of the output tax, which they had paid to the commissioners under Section 80 of the VAT Act, on the basis that their supplies were exempt, and simultaneously assert an entitlement to retain the amounts which they had deducted as input tax on the basis that their supplies were taxable. Can I now please turn to the due question. For reasons I will... can I just identify what the question is? The question is, if VAT has not already been paid back at the time of the original supplies, embedded within the price, but to the ignorance of everybody, can it be said that VAT is nonetheless due within the meaning of Article 168A? That depends, as I'm about to show you, on the meaning of the word due, which the court has interpreted in a case called Velleclaire. Velleclaire is at Primary Authorities, tab 35. MS 1138. Again, just to give you a digest of what the case was about. Velleclaire was an importer of bicycles into France. It became liable to customs duties because of a misdeclaration on the relevant form about the origin of the bicycles which it had imported. And that liability to customs duties triggered a separate liability to import VAT. Velleclaire did not pay the import VAT. It then goes into administration. The French fiscal authority makes a claim against Velleclaire in administration for the unpaid import VAT, but the French courts rule that that claim has been time-barred. But even though it had not paid, or the administrators had not paid the import VAT, they then sought an input tax credit. The first question referred to the court was whether the right to deduct an input tax credit depended on whether the import VAT had actually been paid. And the answer given by both Advocate General Cocotte and the court was no. There was no requirement for it already to have been paid. But the Advocate General and the court also then stated that VAT was not due within the meaning of Article 17 of the 6th Directive, which is the predecessor to Article 168 of the Principal VAT Directive, because the term due refers to an enforceable tax claim, and therefore requires that the taxable person has an enforceable obligation to pay the amount of VAT in respect of which he seeks a deduction as input tax.
This is about due to the taxman, as I understand.
This was
not due to somebody up the chain who,
my lord, yes.
who has made a supply to you.
My lord, yes. But at one level, that is because the case concerned importation of goods from outside the EU, and in those circumstances, the person who has the obligation to pay the VAT to the state is the same person as the person who is seeking to deduct the VAT as input tax. But nonetheless, there are points of principle which emerge from Advocate General Cocotte's opinion and from the court's judgment, which have general application. So can I start, please, with Advocate General Cocotte? Picking it up, please, at MS 1145, internal 286. Paragraph 27. The case law of the court on Article 17.2a of the directive, just to explain, that is the predecessor to 168a, our due or paid provision, which is also based on the VAT due or paid, is clear. Only recently, the court decided that where Article 17.2a applies, the creation and exercise of the right to deduct are in principle independent of whether or not the consideration, including VAT, due for a transaction has already been paid. It is equally irrelevant whether the VAT on the earlier sale of the goods concerned to the end user has or has not been paid to the tax authority. Her footnote takes one to Optigen, and the language in Optigen is similar to the case of Bonnick, which I'll come to shortly. Paragraph 28. It's of course correct, as the governments which are participating in the proceedings assert, that where Article 17.2a of the directive applies, there are always two different people involved who remit VAT and claim the right to deduct, while in the present case it's the same person involved. However, in the end, there may be the same result in factual and economic terms in both cases. And then please, over the page, paragraphs 31 to 32. However, in the same way, there are also no consequences for the taxable person if the supplier doesn't remit the VAT. The taxable person may nevertheless deduct the input VAT. Consequently, in such circumstances, the state may end up having to refund tax, which it has not yet collected, as in the present case of importation. It's accordingly intrinsic to the provision in 17.2a of the directive, that's our provision 168a, that cash flow advantages, not fundamental rights, but cash flow advantages are possible for the taxable person at the cost of the tax authority or the supplier. Accordingly, due to the comparable nature of the situations in economic terms, the fact that in the domestic transaction, which is regulated under 17.2a, the taxable person and the holder of the right to deduction are two different people, doesn't preclude the clear case law on the wording due or paid in relation to 17.2a being applied to the corresponding wording in 17.2b. In that provision too, the right to deduct is already recognised when the VAT on importation is merely due, but it's still got to be due even if it hasn't been paid. And then if one goes forward, please, to MS 1150, internal 291. Paragraph 54. As is apparent from 17.2b, that's the import provision, the taxable person shall be entitled to deduct VAT due or paid in respect of imported goods. It's apparent even from the wording that it's not sufficient that the VAT on importation, which has not yet been paid, was once due in order to be able to deduct it as input VAT. On the contrary, it depends on whether the VAT on importation is actually still due. The relevant time for these purposes must be the time when it is finally decided whether the right to deduct claimed by the taxable person actually exists. Can I just pause for a moment? We have given thought to what is meant by finally decided. Is it finally decided by the tax authority? Is it finally decided on an appeal to the national judiciary? And I'll come on to cover all the bases when I deal with the facts of this case in about 10 minutes. If at this time the state's claim for tax has been extinguished without already having been fulfilled, there can be no longer a right to deduct either. Such an interpretation is also required by the spirit and purpose of the right to deduct, which is to relieve taxable persons entirely of the economic burden of VAT. If this burden no longer exists, because it hasn't been paid and it's not due, there is no need to relieve it by means of the deduction of input VAT. In addition, the question arises as to whether the VAT on import should be regarded as no longer being due under 17.2b, even if, as is apparent in the case at issue, the state's claim for tax still exists but is no longer enforceable. The answer to this question can't be left to relevant national law. On the contrary, in order to ensure the uniform application of common VAT, the term due within 17.2b must be given an autonomous interpretation. The term due does not preclude an interpretation that it requires the legal enforceability of the state's claim for tax. According to the spirit and purpose of the right to deduct, such an interpretation appears plainly to be required. Just as in relation to the state's claim for tax having been extinguished, if that claim isn't enforceable, there is no need to relieve the taxable person of a burden which he must in fact no longer bear at all. 58. Accordingly, the term due within 17.2b of the directive must be interpreted as meaning that it requires that the taxable person has a legally enforceable obligation to pay the amount of VAT which he seeks to deduct as input VAT. If there is no such obligation, he can't be entitled to a right to deduct in respect of VAT on importation which has not yet been paid. Can we then please look at what the court said? Key passages appear at MS 1154, internal 295.
1154.
MS 1154.
Thank you.
Picking it up at the top of the page, by its question, the referring court asks, in essence, whether 17.2b is to be interpreted as allowing a member state to make a right to deduct on importation conditional upon the actual prior payment of the tax, where the taxable person is also the holder of the right. In order to answer that question, first it must be borne in mind that according to 17.2b, the taxable person is to be entitled to deduct VAT due or paid. Thus, the wording of that provision, which repeats the expression used in 17.2a, that's our provision, according to which the taxable persons are to be entitled to deduct VAT due or paid in respect of goods supplied or to be supplied to them, clearly provides that the taxable person's right to deduct that tax concerns not only VAT which he has paid, but also VAT which is due, that is, which is still to be paid. As the Advocate General observed, in points 56 to 58, so they're expressly endorsing this. The term due refers to an enforceable tax claim and therefore requires that the taxable person has an obligation to pay the amount of VAT which he seeks deduction of as input tax. First, it should be added that if the legislature had wished to make the right to deduct VAT on importation conditional upon the actual prior payment, it could have done so explicitly. Second, it follows from the combined reading of 17.1 and Article 10.3 that the creation of the right to deduct is independent of whether payment of the consideration due has taken place, or I add already. It follows that, applying 17.2b, that the right to deduct VAT can't in principle be made conditional upon the actual prior payment of the VAT. That's all I want to go to, so in Velleclaire. And my learned junior rightly reminds me that you wanted to rise at 11:30, and I've gone past 11:30.
If that's a convenient point,
Yes.
we shall return shortly. Yes, Mr. Godziński.
Applying the guidance I've just shown you, can it be said that Zipvit is now, or indeed was at the time it made the input tax claim, subject to an enforceable obligation to pay VAT to Royal Mail, assuming, of course, that it hasn't already done so? The answer is no. First, such an obligation could only arise, as I submitted yesterday, if Royal Mail were to have demanded that the VAT be paid. And the way it would have done that would have been by issuing Zipvit with a VAT-only invoice. It is common ground that no such demand has been made thus far by Royal Mail, and no such invoice has been issued. So thus far, notwithstanding Royal Mail's rights under the VAT exclusive contract, no debt has arisen and become due from Zipvit to Royal Mail. Next, that's the past position. Next, if the present day position is relevant, rather than the historic position when HMRC first decided and refused the input tax claim, which Mr. Thomas rightly showed you the correspondence of back in 2010. So if the present position is the relevant temporal test, then the 6-year limitation period for contractual claims under the 1980 Limitation Act would become relevant. If the VAT was in theory payable from the date of the supply, even without a demand, which one has to hypothesize at this stage of the analysis, then Royal Mail would now be time barred to make such a demand. So in our submission, Zipvit has never been subject to a legal obligation to pay the VAT, because there's been no claim against it for any additional sum of money, and can't now be subjected to it because of the operation of the Limitation Act. That should be the end of the matter. VAT is not due and has not been due under Article 168A. Nonetheless, I'm going to carry on for the sake of completeness. Even assuming a demand for payment of the VAT could in theory still be made by Royal Mail, we observe that there would be no purpose in making such a demand and issuing Zipvit with a VAT invoice. Given that A, it would immediately expose itself, as I've shown my lady and my lords by reference to Article 203, to a liability to pay the VAT, and one has to take into account the fact that the Revenue have not themselves issued any assessment against Royal Mail and will not do so. As I will explain in a minute why Royal Mail will not do so, I beg your pardon, HMRC will not issue such a VAT assessment. But just to make one thing clear before I get there, if Royal Mail could bring a legally enforceable claim to the VAT from Zipvit, which we don't accept, and if it exercised its right to do so by issuing Zipvit with a VAT invoice, then, as I've already said, Royal Mail would then immediately become liable to account for the output tax to the Revenue, and Zipvit would then become liable to a legal obligation to pay it. It would then become due, and Zipvit would then have an entitlement to an input tax deduction. Everything I have just said is perfectly consistent, indeed required by the fundamental principle of fiscal neutrality, by which, and I quote from the case law, the deduction of input taxes is linked to the collection of output taxes. That's what the court said on many occasions, for example, in paragraph 43 of MDDP that I've already taken you to. So the deduction of input taxes is linked to the collection of output taxes. And the way it is linked is that when the taxable customer pays or is due to pay an amount of VAT, or in respect of VAT, to its supplier under the contract, and the taxable supplier issues an invoice and accounts for output tax to the state, the supplier is, as the case law tells us, acting as a collecting agent for the state. And I already said I'm not talking about Bousted and Reynolds, I'm talking about VAT analysis. So it's acting as a collecting agent for the state, collecting the tax from the customer. That principle is long established. Can I take you, please, in support of it, to the Elida Gibbs case, Primary Authorities, tab 26, MS 968, internal 109, paragraph 22. The court says, paragraph 22, sorry, MS 968.
Yes, thank you.
The court says at paragraph 22, it is not in fact the taxable persons, i.e. the suppliers, who themselves bear the burden of VAT, the sole requirement imposed on them when they take part in the production and distribution process prior to the stage of final taxation, regardless of the number of transactions involved, is that at each stage of the process they collect the tax on behalf of the tax authorities and account for it to them. In our submission, it follows from this principle and from the guidance in Velleclaire that I've shown you, that if the supplier, qua collecting agent, has no enforceable obligation itself to collect the VAT from the customer in order to pay it on to the state, and has not taken any action voluntarily, as it were, to raise a VAT invoice and to collect it from the customer to pay it on to the state, then the customer has no VAT burden on it which it can claim as due under Article 168A.
You presume to say that Article 203 really enshrines the collecting agency principle.
It does.
So if you do actually collect the VAT or you invoice for it, then you've got to pay it onto the revenue, even if they haven't assessed you for it.
Absolutely. As I'm going to show you, again, the Advocate General Cockott makes precisely the point that my Lord Woodbridge makes in a passage I'm going to show you shortly. I'm also shortly going to show you why there is no enforceable claim by the revenue against Royal Mail. But before I do that, can I just deal with the case of Bonnick, which Mr. Thomas relied on yesterday for the wide and general proposition that the question of the collection of output taxes by the state is irrelevant to the right to deduct input tax. At the risk of sounding hyperbolic, that is fiscal neutrality heresy. Bonnick. Bonnick is Primary Authorities, tab 22.
Page.
Sorry, MS 921. So, just to remind you, Bonnick was a wheat purchaser. It was seeking an input tax deduction on what it said were its purchases of wheat from its suppliers called F&A. Unlike in our case, it held invoices for those purchases. Nonetheless, the Bulgarian tax authorities didn't accept that the supplies had actually taken place from F&A because they couldn't establish an upstream chain. They couldn't establish how on earth, they thought, F&A could have got the wheat in question. And on that basis, they refused Bonnick's input tax deduction. And you can see all of that from the headnote on MS 921, just reading between letters E and G. If you just read those to make clear the facts. And then, please, picking up the court's judgment, there was no Advocate General opinion. The court's judgment at MS 928, internal 69, para 24. By its questions, the referring court asks, in essence, whether the directive and the principles of proportionality, equal treatment, and legal certainty must be interpreted as meaning that in circumstances such as those of the case before the referring court, a taxable person may not be refused the right to deduct VAT in relation to a supply of goods on the ground that, in view of factors relating to transactions upstream of that supply, the supplier is considered not to have actually taken place. And the statement of...
I'm just making sure I understand upstream.
Upstream means F&A, and before that, F&A's own suppliers.
Yeah.
So,
Okay.
How did F&A get wheat from its suppliers?
correct.
Yeah.
It's a kind of forensic exercise as to which the tax authorities had their doubts. And then the general statement of principle, which my learned friend, I think, relies on, is at paragraph 28. The question whether VAT payable on the prior upstream or subsequent downstream sales of the goods concerned has or has not been paid to the public purse is irrelevant to the right of the taxable person to deduct input tax, see Optigen, etc., etc. But that is a completely different proposition to say that it doesn't matter, I think Mr. Thomas goes this far, it doesn't matter whether VAT is even due anymore as a matter of output tax to the state. We'll see what he says, and I see my Lord Briggs looking askance, but I think that's as far as he took Bonnick. I think he said basically there's no connection between the right to deduct input tax and any concept of the collection of output tax by the state. And that is not what Bonnick says. Can I just address one other question raised by my Lord Briggs in argument yesterday? You looked at paragraph 29 in the same judgment, just on the top of the next page, where it says, in addition, it's apparent from the wording of Article 168A that in order to have a right of deduction, it's necessary first that the interested party be a taxable person within the meaning of that directive, and second, that the goods or services relied on to give entitlement to that right be used by the taxable person for the purposes of his own taxed output transactions, and that as inputs those goods must be supplied by another taxable person. And the question I think my Lord asked was, is that a comprehensive statement of
Yes.
all the substantive requirements? To which the obvious answer is no, because it makes no mention of due or paid.
Well, absolutely, yes. But apart from due or paid,
Apart
is there
from-
anything else?
I'll have to. Can I think about that? I think the answer is probably no. But the main point I want to emphasise is that although that passage 29, as is the way, gets repeated over and over in the court's various judgments,
Yes.
it does not purport to be, can't be, a comprehensive definition of the substantive requirements. Sorry, what do you say? The other point to make, of course, I've already inferentially made, is there could have been no dispute about whether Bonnick's own suppliers, F&A, had an obligation to account to the Bulgarian tax authorities for the output tax on their grain sales to Bonnick, because they'd issued VAT invoices. So, pursuant to Article 203, they had an obligation to pay the VAT to the state. So, my learned friend's suggestion that Bonnick is some seminal authority that breaks the principle of fiscal neutrality in half and says that there's no connection between the collection of taxes by the state and the right to deduct input tax is wrong. Can I then turn to explain, please, why Royal Mail is subject to no legal obligation to account to HMRC for the VAT in the sense of having an enforceable debt due. And as I've already said, that is so for the reasons identified by the first tier tribunal at core volume tab 8, MS 213, paragraph 137, so it's MS 213, internal 211. There was no enforceable tax claim against Royal Mail. HMRC could only enforce against Royal Mail its liability to pay VAT due on the mail media supplies in one of 4 situations. The VAT was declared by Royal Mail in its VAT returns. The VAT was later declared in a voluntary disclosure. Royal Mail issued an invoice showing the VAT as due, see Schedule 11, paragraph 52 of the VAT Act implementing Article 203, or HMRC assessed Royal Mail to pay it. It is no answer to any of those points for Zipvit to say simply that following TNT, we know that the supply was chargeable to tax under Articles 62 and 63 of the directive. The definitions of chargeable transactions, which are encompassed under Title 6 of the directive, and the substantive preconditions to the right to deduct, which are encompassed under Title 10 of the directive, including presently Article 168, are not the same, and a right to deduct does not arise simply because a supply is chargeable. There is no authority for such a proposition in any case law, and it's contrary to the whole structure of the Principal VAT Directive. Now, of course, in ordinary cases, if there has been a chargeable supply of goods or services and the supplier has failed to account in its VAT returns, HMRC will generally assess the supplier, provided it gets to know about it. We know that HMRC did not do so. And, we're back to limitation here, it would now be out of time to assess Royal Mail in light of the statutory limitation periods, not in the Limitation Act, but in the VAT Act, particularly sections 73 and 77, which provide a long stop, save in fraud and similar cases, of a 4-year time limit.
Section 73,
And 77. So, as of today, it certainly cannot be said that there is any enforceable tax claim by the revenue against Royal Mail. Furthermore, although Mr. Thomas yesterday complained that it was somehow remiss, or to use his words, surprisingly, given this is not a tortious concept that can arise in this case, negligent, I think he used the word, for HMRC not to have assessed Royal Mail, there has never been any challenge, obviously there couldn't be a private law challenge in tort, but there has never been any challenge, public law challenge, of HMRC's decision not to assess Royal Mail. Now, if Zipvit had, before expiry of the Section 77 statutory time limit, wished to bring proceedings in public law challenging the revenue's conduct or decision not to assess Royal Mail, either with VAT on top or VAT embedded, it would have had to do so by way of a claim for judicial review. That's the only way it could have challenged it. It did not challenge it, and it would now be long out of time to do so. But it's not in the least surprising Zipvit did not do that, because that would have then triggered a VAT obligation on them to pay, which is exactly what they don't want to do. Now, in the absence of such a challenge, our primary position is that this court can and should proceed on the basis that the decision by the Revenue not to assess Royal Mail was lawful. I'm not going to go into all the public law, case law, on presumptions of legality in the absence of challenge, but the presumption is the public authority acts lawfully unless the court says otherwise, and the court has never said otherwise. So we don't suggest that it's necessary for this court to decide the question of whether there would have been something as a matter of public law preventing the Revenue from assessing Royal Mail. But if you are against me on that for any reason, or you think it would be relevant to analyse whether HMRC acted lawfully in not assessing Royal Mail, the answer is the one I have already foreshadowed, in particular in answer to my Lord Sales question. The answer is the Revenue did act lawfully, in particular because to have raised an assessment would have offended the EU law principles of legitimate expectation and legal certainty. I'm going to spell out why that is so. Until the judgment in TNT, everybody, the Revenue, Royal Mail, and Royal Mail's customer, in this case Zipvit, were operating on the basis that the exemption in national law, and indeed altogether, applied to the conveyance of all posts by the Post Office. Now, in his early part of his submissions yesterday morning, Mr. Thomas sought to cast doubt on that by saying, well, this was all up in the air long before the decision in TNT, so this was all a matter for some doubt. People didn't assume that. With respect, and the risk of making a forensic point, that is precisely the opposite of what he said all the way through these proceedings until he said it on his feet in court. Could I take you, please, to Appendix Part 2, MS 560, which is at tab 39 of Appendix Part 2. It's the appellant's skeleton argument, Mr. Thomas's skeleton argument, in the upper tribunal, MS 560, internal 318.
Paragraph
3. The dispute between the parties centres on whether Zipvit was entitled to claim input tax for the VAT which Royal Mail should have accounted to HMRC in respect to the relevant supplies. The appellant accepts that until the decision of the European Court of Justice in TNT, it had generally been assumed that such supplies were exempt supplies for VAT purposes. Somewhat unattractive for him now to say precisely the opposite. Anyway, regardless of that forensic point, the fact that everybody assumed that the supplies were exempt is unsurprising, given on its face what would appear to be the clear language of Group 3, Schedule 9, as it stood at the time. Can I give you the reference? It's in the supplemental bundle, the pale blue bundle of authorities. It's called supplemental bundle, tab 3, page 12. You can, again, it's not a very user-friendly page, but you can see from the top of the page what it is. It's Schedule 9, Group 3, Paragraph 1. You can see from the version number 2 of 4 that this is what the Act looked like at all material times concerning the supplies in this case, namely March 2001 to December 2010. Item 1 said the conveyance of postal packets by the Post Office Company. Not only those pursuant to a universal service obligation or excluding those individually negotiated.
I'm sorry, I have a page number problem.
I'm sorry.
I'm in the supplemental bundle,
Hopefully you don't have tabs with the electronic. I hope it's page 12. Does
Yes,
the
wait a
report
minute.
have that?
Yes, I've got it. Yeah.
Great. So it's, just to take my lord back through it quickly, it's the relevant group exemption as it stood at the time of the supplies in this case, and it simply said at item 1, the conveyance of postal packets. Just to chart the history of the legislation through, after TNT, Parliament amended the legislation. The amending legislation, or the amended legislation, following Finance Number 3 Act 2010, that came into effect with effect for supplies of postal services made from the 31st of January 2011. Can I just show you that? Its additional authorities. Volume 1. Tab 4. MS 1188. Internal 11. So this is the successor to what I just showed you. Same group, same paragraph, version 4, October 11 to the present. Item 1, the supply of public postal services by a universal service provider. Quite different. This is not me attempting to resolve from my leasing acceptance.
So your acceptance was in relation to the first one you showed us, leasing
Yes.
would apply, and you
Yes.
read it down in
Yes.
the same way.
Yeah. But Parliament then amended it to be much more closely aligned to what TNT had expressly decided. And in the notes, note 2, subject to the following notes, public postal services in relation to a universal service provider means any postal services which the provider is required to provide in discharge of a specified condition. Public postal services include those which a universal service provider provides to allow a person access to the provider's postal network. Services are not public postal services if the price is not controlled by or under a specified condition, or any of the other terms on which the services are provided are freely negotiated. And you can see over the page in the notes that this paragraph of the group was substituted by, as I said before, Finance Number 3 Act 2010, with effect from or for supplies made on or after 31st of January 2011. I suppose in theory Parliament could have left it as it was before and predicted that it would be found judicially that you could lease it, but they didn't do that. But the point I'm simply seeking to develop here is that it is entirely unsurprising, given the wording of the earlier Act, that everyone proceeded on the assumption that the supplies were exempt. And then in addition to that, in addition to the legislation, there were statements, categorical, clear, unqualified and devoid of any relevant qualification, the language of MFK, in HMRC's publications. Can I take you first, please, to a notice issued by the state in April 2003, Core Bundle, tab 10, MS 231, internal 229. It's notice 700/24, heading Postal and Delivery Charges, paragraph 1.1. What's this notice about? It explains how VAT applies to charges made for postage and delivery services. What's changed? The notice has been restructured and rewritten to improve readability. Over the page, please. Who should read this notice? You should read this notice if you supply goods which you deliver to your customer, you provide a delivery service involving other people's goods, or you operate a direct mailing service. Aren't postal charges exempt from VAT? Postal services provided by the Post Office are exempt from VAT. but this exemption doesn't extend to similar services provided by other suppliers, even where they might be seen to be in direct competition with the Post Office. And it's that asymmetry that led to the TNT litigation. But on the face of it, this is a clear statement, unequivocal and devoid of any relevant qualification, that postal services provided by the Post Office are exempt.
And you referred to the MFK standard, but in fact, I think you said what was relevant was the EU principle of legitimate expectation.
And that's exactly what I'm going to take you to.
All right.
Can we start, please, in additional authorities?
That would tally with the British approach to legitimate expectation as well.
The MFK test, which
Yes.
is the MFK underwriting test, judgment of Lord Justice Bingham, as he then was, is the sort of locus classicus of what the criteria are for a substantive legitimate expectation.
Yes.
The position in EU law is very similar, if not identical. I'm going to show you that.
Yes, I remember there was a litigation involving HMRC and Alfred in the early years of the millennium.
Yes.
And there the issue was whether one could have a legitimate expectation of the continuance of an ultra vires act. And the answer was no. But one could have a legitimate expectation that if you've been misled in respect of the past, the revenue couldn't go back and sort things out.
Yes.
Which is consistent with MFK. I think it all turned on MFK.
It is. Well, I don't want to get too much. It's a topic close
No.
to my heart, but
No.
Whether all that can be consistent with Article 1, Protocol 1, we don't need to get into today.
No. No.
Can I show you the two cases of EU law that are relevant?
Yes.
They're both in the additional authorities. The first in time is the Elmica case. Additional authorities, tab 1, I beg your pardon, volume 1, tab 28, which starts at MS 1311. I'm just going to take you to the operative paragraphs of the court's judgment. They are paragraphs 32 and 36, which are at MS 1344, internal 167. Paragraph 32. As regards the principle of protection of the legitimate expectations of the beneficiary of the favourable conduct, it's appropriate first to determine whether the conduct of the administrative authorities gave rise to a reasonable expectation in the mind of a reasonably prudent economic agent. And then the last sentence, if it did, the legitimate expectation of this the legitimate nature of this expectation must then be established. Then paragraph 36 over the page, the numbering is a bit obscure, but it's the third paragraph in the middle of page 1345. In the light of the observations, the answer to the third question must be that in the framework of the common system of VAT, national tax authorities are obliged to respect the principle of protection of legitimate expectations. It falls to the referring court to decide whether in the circumstances the taxable person could reasonably have believed that the decision in question had been taken by a competent authority. The case law is expanded a little, please, in the same bundle, tab 40. Oh no, it can't be the same bundle. It's the case of Salome. I've got it in my notes as tab 44. Yes, it's volume 2, please, of the additional authorities bundle. Tab 44. MS 1642, internal 465. Case of Salome and Oltean. Picking it up at the top of MS 1642, internal 465, para 44. In the second place, in relation to the principle of the protection of legitimate expectations, the right to rely on that principle extends to any person in a situation in which an administrative authority has caused that person to entertain expectations which are justified by precise assurances provided to him. In this regard, it's necessary to determine whether the conduct of the authority has given rise to a reasonable expectation in the mind of a prudent and well-informed trader, and if it did, the nature of the expectation must then be established. As described in the order for reference, the administrative practice of the national tax authorities nevertheless doesn't appear to be such as to show that those conditions are satisfied in that particular case. Now, there is no equally developed case law on, for example, the extent to which in EU law you need detrimental reliance, as you do as a matter of English common law. If there were such a requirement, however, it would be satisfied. Why would it be satisfied? Because if for years the Revenue and Royal Mail operated on the common understanding, which was affirmed by a clear representation in guidance, that VAT did not have to be charged, what would be the result if that expectation were reversed? Royal Mail would then have to go back for years, identify all its past customers, and ask them, rather hopefully, whether they would please pay an additional amount of VAT. It would be a huge administrative exercise, and requiring them to do it would be contrary to their, or be detrimental to their position.
I mean, I appreciate you say we don't actually get into all of this.
Yes.
The principle of presumption of legality. But in domestic law, if you have an ultra vires assurance, that doesn't give rise to a legitimate expectation. And couldn't it be said that if Royal Mail has given the assurance in paragraph 1.4 of its guidance that VAT is not due on all post office services, whereas in fact it was due on some, that is an assurance which is ultra vires in our terms, but contrary to the EU treaty?
Well, my Lord will know that the EU, in domestic law terms, pure domestic law terms, that may be right. But the position is different in EU law terms for the reason my Lord has just identified. And moreover, the matter might also be contrary, as I intimated before, to...
I'm so sorry, I don't think I did identify.
I'm sorry.
I was saying, won't it be the same? So I was saying...
No, not necessarily.
Right,
I wouldn't
that's what
necessarily
I'm asking
accept...
for help on.
Well, it can't be that EU law, which is, for the time being at least, trumps English law, including English domestic law, if there has been a breach of a legitimate expectation, the mere fact that the national authority has created that legitimate expectation ultra vires its own powers, ultra vires its own domestic law powers, can't affect the EU law result.
No, I was meaning ultra vires its powers under EU law in operating the treaty, because the treaty on proper interpretation, as
penny's
we know
finally dropping
from TNT, said actually you can't exempt the individually negotiated supplies of the post office. And therefore, I was just suggesting to you an analogy with the limitation on the English law of legitimate expectation and querying whether that wouldn't apply in Europe. And in support of that, it might be said, if states could go around giving assurances to their citizens that EU law would not be applied, and then it turned out that they had misunderstood EU law, the states would be defeating the due operation of EU law. It seems a little bit surprising that EU law would be completely content with that.
Well, but, part of the answer to that is that not precisely how I put it. I don't say that any assurance was given by the state that EU law wouldn't apply.
No,
plainly, at the time that the assurance was given, it was understood that what it said was compatible with EU law. It later turns out to have been wrong about that. There may be an interesting question about whether a public authority, including a tax authority, can, in the reasonable discharge of its duties under the Commissioner of Revenue and Customs Act 2005, in order to give guidance to taxpayers, adopt a perfectly reasonable interpretation of what it understands the position to be, both as a matter of English law and as a matter of EU law, and can then be held to it. I mean, one can think of the analogy in European Convention on Human Rights terms, where there are authorities that say that if you enjoy a legitimate expectation consisting of a substantive right, that qualifies as an A1, P1 possession, and the fact that it was given ultra vires does not trump that.
I mean, it just strikes me that this is potentially quite a difficult question on which we've had haven't had argument from Mr. Thomas, and you're introducing it in this rather tangential way. I don't think it was addressed in the courts below.
It was addressed in our written arguments in the courts below. It's addressed in our written case in this court.
Right.
The way I put it below, in a stage I haven't expressly spelled out.
But am I right in thinking the courts below did not grapple with this? You may have addressed it in your argument.
Well, Judge Mosedale touches upon it and refers to the public law issues in very broad terms, but there's certainly no definitive ruling on it at any stage below. I said before, it may not be necessary for this court to grapple with the issue, and the court may decide, in light of my Lord Sales's concerns about the complexity of the point, not to do so. The only thing I would say is, as I said below, is if the burden in these appeals throughout has always been on the appellant. If the appellant is to say that it was lawful for Royal Mail to assess, HMRC to assess Royal Mail, and that it should have done so, the burden is on it to say that. Now, I've already made my submission that it's frankly too late, because if it was going to make such a claim, it ought to have done so by way of a claim for judicial review back in 2009 or possibly 2010. It's long out of time to do so, and therefore the legality of HMRC's conduct stands. And that's our primary argument as to why this whole legitimate expectation analysis, interesting though it is, doesn't need to be grappled with. I was only grappling with it as a fallback. Sorry. Okay. My learned junior makes a point about the nature of the error made by the Greek authorities in Almika, which was also contrary to EU law. I'd like to have a look at that over lunchtime, if I may, and make any submissions I need to after the short adjournment.
I'm conscious that your main submission is you don't need to go there.
Yes.
But if detrimental reliance does matter, you've dealt with detriment, but I'm not sure you've dealt with reliance. And it's perfectly possible, isn't it, that a large organisation like Royal Mail would form its own view about the extent of the exemption, rather than rely on the revenues publication.
I accept that, my lord.
Okay.
Yeah. Or it might be so they didn't look at the guidance.
Well,
What they looked at was the
I
legislation.
just wonder if there's any evidence about that in the bundle.
No, there's not.
No.
That's all I want to say, at least for now, on legitimate expectation. And all I want to say for now on EU law. Can I then turn, before I get to the invoice issue, on the domestic law provisions and authorities about the due or paid issue, and in particular deal with Section 19, Section 36, and Simpson and Marwick, and Mason and Boscoe, and those are the cases that my learned friend relies upon. The first question, of course, concerns the effect of Section 19.2 of the VAT Act. Our overall submission is that this provision does not operate in a way which displaces the requirements of EU law, as explained in the Court of Justice jurisprudence that I have taken you to. In other words, it would be contrary to EU law, and our leasing operates here just as much as it does in any other context, to interpret Section 19 as saying that VAT has been paid, embedded in a price, when it has not been. And if my lords and my lady accept my submissions on Tulica, Volkswagen and Biosafe, it cannot be that Section 19 has an effect contrary to that analysis. I flagged yesterday a inconsistency, not an unlawful inconsistency, but an inconsistency in the language between Section 19.2 and Articles 73 and 78A in how they use the word consideration. And it's quite important to keep the distinction in mind, because if you lose sight of it, it's apt to confuse. In Section 19.2, the word consideration refers to the total amount of money payable under the contract and includes expressly both the amount attributable to the value of the supply and the amount chargeable to VAT. In Articles 73 and 78A, by contrast, the word consideration is used differently. It is equated to the taxable amount, which corresponds to the value of the supply itself and excludes VAT. And we can see that in the primary authorities, tab 12. Perhaps we should look at section 19 first, just to flag up the point. It's primary authorities, tab 4, MS 871. Section 19.2 says, if the supply is for a consideration in money, its value, i.e. the value of the supply, in other words, what the supply is worth, the postal service, the financial advice service in the ITC case, etc., etc. Its value shall be taken to be such amount as, with the addition of the VAT chargeable, is equal to the consideration. So, value, VAT, consideration. That's different in Article 73 to 78. Tab 12, please, MS 887. Article 73, bottom of the page. In respect of the supply of goods or services, ... taxable amount shall include everything which constitutes consideration obtained or to be obtained by the supplier in return for the supply. That's what I call the principal sum or the fee, the value of the service. And then Article 78, the taxable amount shall include the following factors: taxes, duties, levies and charges, excluding the VAT itself. So, as I submitted yesterday...
Well, consideration's not being used differently, is it? But they focus... I'm not sure that they're using consideration differently, but they're using taxable amount for a specific purpose, to identify the amount on which the VAT is calculated.
Yes, but VAT is not included in the consideration, whereas in section 19.2 it is included in the consideration.
Well, it's... Sorry.
78A specifically carves out of the term consideration.
Yeah, but not from the consideration, it's from the taxable amount.
Yeah, so there's... Well... sorry. Yes, the taxable, but the you know from 73 that the taxable amount shall include everything which constitutes consideration.
Yes.
Consideration doesn't include VAT. We know that from 78A. I mean, maybe it's a distinction.
But you've got to read 73 and 78 together.
Yes, of course you do. It may be that it's a distinction without a difference. I just wanted to flag up the difference. I'll move on.
I'm not sure it's going to affect very much.
No, I don't think it is. In any event, in our submission, there is nothing either in Articles 73 and 78A or in Section 19.2 which operates retrospectively to alter the taxable amount in Article 73 and 78A terms, thereby deeming VAT to have been included in the money paid by a customer to its supplier, when at the time the supply is made, the contract provides that the sum payable is exclusive of VAT, and where no sum relating to VAT was paid at the time or has been paid since, because the parties understood the supply to have been VAT exempt.
But, I mean, I thought in Tulica, the CJU accepted that if you just have a supply under an invoice which has no VAT element, the parties assuming that VAT was not due, that in EU law terms, the supply would be treated as having embedded within it VAT element.
But that was on the hypothesis, my lord, that the contract was silent about whether VAT was included or not. So, by definition, it is not the same as a contract like in our case, where VAT was said, where the contract price was said to be VAT exclusive.
I appreciate that you're saying our case is different, but I may have misunderstood, but you seem to be saying something broader, that EU law didn't itself have a concept of embedded VAT in any circumstance.
No, I'm not going that far. I'm accepting that if either a contract says this is the price and VAT is included, or the contract is silent and applying national rules of interpretations of contract, which I'll come to very shortly and briefly in a moment, you imply into the contract a term which is VAT is included, then there is included VAT.
So your target is simply that Section 19.2 doesn't overcome the contractual term.
My lord,
That the taxable amount is exclusive of VAT.
My lord, yes. Can I just illustrate that in a minute with an example, but make the fundamental point that I think my Lord Hodge was effectively just making, which is that to read Section 19.2 in that way entails rewriting the parties' contractual relationship. If £100 is paid at the time of the supply, and the parties agree that that £100 represents the value of the supply, exclusive of any VAT, Section 19 does not operate so that the parties can later deem £16.67 to have been paid, because what would be the effect of that? It would be to reduce the value of the supply, in commercial terms from £100 down to £83.33. And I'm going to show, my lords, in a minute why that's inconsistent with the case law. But before I turn to Section 36 and to Simpson and Marwick, can I illustrate my learned friend's argument, or the error of it, with this simple example, which we've already given in paragraph 65 of our written case, MS121. Assume a situation where the parties to a supply contract believe that the supply is taxable, chargeable to tax in the language of the directive. And they expressly agree that the amount payable, the total consideration in Section 19 terms, is 120. 100 plus £20 VAT. £120 is duly paid from the customer to the supplier. The supplier duly accounts for £20 of output tax to the state. There's then a Court of Justice decision. It turns out that the parties were wrong, that the supply is not exempt. I beg your pardon, that the supply is not taxable after all. That would, on its face, entitle the supplier to recover £20 output tax from the state. It would do that, generally speaking, in a claim under Section 80 of the Act, as happens from time to time, and has happened in one case I'm about to show you. On Mr. Thomas's interpretation of the English legislation, including Section 19.2, the whole of the £120 would, irrespective of everything I have just said, have to be recharacterised as all being attributable to the value of the supply. None of the money on his terms, on his analysis, would be attributable to VAT, and the supplier, in that hypothesis, would be unable to recover the £20 from HMRC and would be unable to pass it back on to his customer through what are commonly called reimbursement arrangements. But that is obviously not the position the supplier can recover £20 from the revenue, subject to the revenue being able to advance a defence of unjust enrichment, which is generally met by the supplier who's claimed the VAT back from the state, agreeing reimbursement arrangements to pass it back down the chain to its customer. And that example, that hypothetical example I've just given you, has a real-life analogue in the investment trust case that I mentioned earlier. That is at the second supplementary bundle tab 3. So it's the white-fronted bundle. I'm looking at the time, and I know what else I've got to cover, including all the invoice issues. I'm not going to take up a lot of time giving you a detailed description of the case. In a nutshell, as my Lord Hodge may recall, the position was that investment management services had been supplied by managers to investment trust companies, the claimants in this action, at a time when, as in my hypothetical case I just gave you, the supplies were believed to be taxable. The contracts provided for VAT to be paid in addition to what were called the fees, if VAT was applicable, as it was perceived to be. Following a decision of the Court of Justice, so the analogue to the TNT decision, it was a case called J.P. Morgan Fleming Claverhouse, it became clear that the supplies had after all been exempt, not chargeable to VAT. The investment managers, so the suppliers, the equivalent of Royal Mail in our case, were granted refunds, certain refunds anyway, from the revenue pursuant to Section 80 of the VAT Act, of the output tax which they had accounted for historically. There were arguments about the effective limitation periods, etc., which aren't necessary for us to go into today, but that was the basic framework. And they agreed, in order to avoid an unjust enrichment issue arising, to pass it back down the chain in reimbursement arrangements to their customers, the claimants in these proceedings, the investment trust companies. Now, there were lots of issues litigated all the way up to the Supreme Court, in particular as part of the investment trust company's restitution claim for what they hadn't received as a result of mismatches between output tax and input tax, and as a result of the operation of statutory limitation periods. So a restitution claim was litigated all the way up to this court. But the simple point I want to make, going back to my hypothetical example, is that if Mr. Thomas's argument on the effect of Section 19 were right, then the complete answer to all these claims, including the manager's claim to the repayment of the VAT, and indeed to the entire restitution claim brought by the claimant against the revenue, would have been to say, well, Section 19 recharacterises all of that. All the money originally paid by the claimants to the investment managers was fees. None of it was VAT. That solution, I'm not suggesting that argument was even run by anybody, but that would have been the complete solution to the case. Can I just show you a couple of passages in the judgment of Lord Reed? I'm not going to take up much time, given the pressure. But if you look, please, at Internal 43, Appeal Cases 286, the basic factual framework is set out in Lord Reed's judgment at paragraphs 4 to 5 on page 286. And at letter E, he says, uncontroversially at E, the customer's liability to pay an amount in respect of the tax rests upon the contract. That's all I want to say on Section 19. I now want to turn to the bad debt relief issue, Section 36 in Simpson and Marwick. I think my learned friend says that this shows effectively that Parliament has...
Sorry, just before we move on from section 92, what function do you say it performs?
It performs what I called it in opening, a ready reckoner valuation provision, and operates so that when the parties are silent as to VAT, you know that VAT has been included in the price. So when I go into a supermarket and I take something off the shelf for £100 and it doesn't expressly say VAT on the ticket, but it's a chargeable item in the supermarket or in the shop, VAT is included. It doesn't allow, it doesn't generate a fundamental ingredient to an input tax recovery claim, as in this case.
Yes, thank you.
And as I said before, if that was its function, or if that was its effect, it would be inconsistent with what I've shown you in the Court of Justice case law, in particular in Volkswagen and Biosec. Can I then turn, please, to section 36, the bad debt provisions? He says, effectively, this shows that Parliament is always treating part of an amount paid under a contract as embedded input tax, regardless of what the parties agreed. In our submission, for three reasons, that is not the position. First, for the risk of repeating myself, if that was what Parliament was saying, it would be inconsistent with the Court of Justice case law. Second, as the first-tier tribunal, upper tribunal, and unanimous Court of Appeal all said, Section 36 has nothing to do with the right of a customer to deduct input tax. And third, and perhaps most importantly, Mr. Thomas's argument ignores the fact that Zipvit has never been subject to any obligation at all to pay the further sum to Royal Mail. It's never received a demand for payment in the form of an invoice, and Royal Mail has therefore never accounted for any VAT on the supply. And in those circumstances, the bad debt provisions of Section 36 implementing Article 90 don't apply. Can we look, please, at Section 36, Primary Authorities, tab 9, Internal 22, MS 881. Bad debts. Subsection 2 below applies where a person has supplied goods or services, that's happened, and has accounted for and paid VAT on the supply. That has not happened. Royal Mail has not accounted for and paid VAT on the supply. B, the whole or any part of the consideration for the supply has been written off in his account as a bad debt. Again, that wouldn't apply. How can Royal Mail have written off something as a bad debt when it's never brought a claim for that debt against Zipvit in the first place? So far as Royal Mail is concerned, it charged Zipvit £100 for the value of the supply. It received £100 for the value of the supply. Nothing remains unpaid. And all of that is precisely consistent with Article 90 of the VAT Directive, which Section 36 implements. Article 90 is Additional Authorities, Volume 1. Tab 18, MS 1215, Internal 38. That says, under the heading Miscellaneous Provisions, in the case of cancellation, that doesn't apply, refusal, that doesn't apply, or total or partial non-payment, or where the price is reduced after the supply takes place, the taxable amount shall be reduced accordingly. The taxable amount, you recall, is the value of the supply. But there has been no non-payment in this case. And there's nothing to support any conclusion that the taxable amount, the value of the supply, should be reduced. So Section 36, consistently with Article 90, just has no application to the present context. And that is why...
There hasn't been a payment under the general conditions obligation to pay any VAT which is due, but you say that never matured into a debt because it wasn't demanded.
Yes.
Right.
And that's all completely consistent with the Court of Justice case law on Article 90 and its predecessor in the 6th VAT Directive. My learned friend took you to a couple of cases. Given the time, I'm going to just take you to one. It's the case of Goldsmiths. Primary authorities... Sorry, I've got the wrong reference. Tab
Goldsmith,
27.
it's 976.
Yes. MS 979 is the passage I want to take you to. Paragraph 16, second sentence, 4 lines down. That provision, that's Article 11C1, which is the predecessor to Article 90, requires member states to reduce the taxable amount and consequently the amount of VAT payable by the final consumer, taxable person, when after a transaction has been concluded, part or all of the consideration has not been received. But the consideration in VAT directive terms excludes VAT. So there's nothing inconsistent about Goldsmiths in what I've said, nor is any assistance derived from Simpson and Marwick. Simpson and Marwick, you will recall, simply concerned how Section 36 operated in the rather unusual three-party situation where the supplier of legal services, Simpson and Marwick, issued what it called fee notes to its insurer clients and separate VAT invoices to the policyholders. Again, given the time, I'm not going to go through it. Lord Justice Henderson addressed the case in detail at paragraphs 72 to 77, and we respectfully agree with everything that he said. Nor does the case of Mason and Boscowen apply. That's the rent case. Again, we echo what Lord Justice Henderson said about the limited relevance of this case at paragraphs 63 to 65 of the Court of Appeal's judgment. I'm going to take you just to one passage in the Mason and Boscowen judgment of Mr. Justice Lewison. It's at Primary Authorities, tab 29, at page MS 1027, paragraph 52, bottom of page 1027, internal 168. I'm not going to read out the whole of this rather long paragraph. Picking it up at Roman numeral 2, the prima facie rule under the VAT Act is that some agree for the supply is inclusive. Below, Mr. Thomas placed significant reliance upon that particular subparagraph, but as I submitted below and as the Court of Appeal accepted, the important words in that subparagraph are prima facie. It's a reference to section 19, but it can be displaced. And then over the page, please. Roman numeral 6. If an all-inclusive rent is agreed and the rate of VAT subsequently changes, the amount of the change is added to or deducted from the consideration for the supply. The same applies if the landlord and tenant agree a rent at a time when no VAT is chargeable, but VAT subsequently becomes chargeable. What happens is that the consideration for the grant is increased, not you regard it all as embedded in the amount in the first place. So it's an additional amount. Can I finally, before turning to the invoice issue, deal very briefly with the other hypotheses? By other hypotheses, I mean what happens when a contract is stated to be VAT inclusive and what happens when the contract is silent. We've already made our position clear on what happens if the contract is VAT inclusive. We've said in our written case at paragraph 80 that if the Royal Mail's contract with a customer had stated that the price payable was VAT inclusive and the full amount was paid, we accept that VAT would have been paid within the price. That doesn't mean that the invoicing requirements would be met, but the paid element of 168A would be met. As to what the position would be if the contract was silent, we deal with that in paragraph 78 of our written case. Could I just ask you to turn that up briefly? It's at tab 7 of the core volume, MS 123, internal 121. We say there's a fourth possibility where the contract doesn't expressly provide whether it's inclusive or exclusive, but where the parties have agreed a price on the express basis that the supply was exempt from VAT. We submit that in such a case a term is properly to be implied that the price is exclusive of VAT, and we give the references to this court's judgment in the now leading M&S case on contractual construction. I won't ask you to read all that now. What I will do is take you to an entirely consistent analysis, i.e. consistent with that, in the recent judgment of Mr. Justice Mann in the Royal Mail Group litigation. Could you turn, we obviously didn't have when we wrote the written case, could you turn please to the supplementary tab 7, one of the preliminary issues decided by Mr. Justice Mann in this GLOW trial was what terms could be implied as a matter of contract in a case where the contract was silent about VAT, but where the parties were proceeding on the assumption that the postal supply was exempt. And the question was about whether a term could be implied to the effect that Royal Mail was required to provide a VAT invoice showing part of the price paid already having VAT embedded in it. And the judge said no such term could be implied. Could I take you, please? He sets out all the M&S case law on on interpretation of contracts, etc., from paragraph 71. We don't need to go through that. But the operative parts, can I take you, please, starting at paragraph 154.
Page?
84.
84?
Yeah. This is under the heading at the bottom of the previous page, contractual duty implication. In oral argument, Mr. Cordara, that's for the Zipvit analogue, contended for 3 alternative versions of an implied term, each of which was alternatively suggested to be sufficiently obvious to pass the implied term test. They were an obligation to supply a VAT invoice whenever a taxable supply was made, an obligation to supply a VAT invoice whenever a taxable on request whenever it was made, and whenever it was made on reasonable request. And the judge dealt with that at paragraphs 162.
Something faintly odd about advancing 3 alternative implied terms and saying all 3 are equally obvious, although different, to be implied.
Well, the judge made fairly short shrift of all of them for the reasons I'm about to show you. Paragraph 162, this is where the judge is taking different sorts of contractual general T's and C's. I take example 1, parcel force. This contract made no reference to VAT, and the assumption is that the parties didn't think it was chargeable. In order to get to one of his first 3 types of implied term, the officious bystander would have to ask, will a VAT invoice be provided whenever a taxable supply is made, and receive the answer, of course. But that wouldn't happen. If that question were answered, the parties would say, yeah, but that doesn't apply to this transaction because everyone knows it's exempt. Anything else would be nonsensical. The response would not generate the term which Mr. Cordara requires. The same applies to the formulations based on request or reasonable request. In fact, the question is loaded. because it assumes a state of affairs which is not in the parties' minds and does not invite them to address it. The more proper way of testing obviousness would be to propose a question which reflected everybody's state of mind and the legislation and ask if, contrary to your shared understanding, it turns out that this transaction is not VAT exempt, should RM issue a VAT invoice in the gross amount reflecting VAT as part of that sum? Whatever the customer might say, Royal Mail would never say of course to that. The reason for that is to agree to render a VAT invoice of the kind required by Mr. Herberg. That's a typo. I checked with Mr. Herberg at about 10 o'clock last night, and he said, oh yes, I didn't pick that up on the list of typos. That should say Mr. Cordaro.
Yes.
It's pretty obvious. Of the kind required by Mr. Cordaro would expose Royal Mail to a financial risk and to upsetting the agreed commercial deal. If it rendered an invoice, it would be obliged, or at the very least be exposing itself to an obligation to render the relevant VAT to HMRC. Mr. Cordaro sought to say that was no longer a risk in this case because the limitation periods for liability contained in sections 73 and 77 meant that there was no exposure. Mr. Herberg sought to say there was still a potential exposure under Schedule 11, which Mr. Cordaro disputed. I don't need to deal with the real effect of this legislation. The fact is that Royal Mail would perceive a risk of a substantial liability, and it must be remembered that the question must be considered at the date of the contract, not at the present date after the lapse of so much time. That potential liability, if it eventuated, would upset the commercialities of the transaction, with a customer paying much less than he bargained for and Royal Mail receiving much less than it had agreed. That's why I say Mr. Cordaro and Mr. Thomas's argument on section 19 can't work because it involves rewriting the contract and ascribing a lower value to the value of the postal supplies, as this paragraph accepts. So in our respectful submission, where a contract says nothing, but the parties proceeded on the common understanding that the supplies were exempt, the result would be the same as in a VAT-exclusive contract, because you couldn't imply a term saying it was VAT inclusive. If anything, it's the other way. That's all I want to say, and I now need to turn to the important invoice issue. It's common ground that the only invoices in this case that were issued by the Royal Mail showed that no VAT was chargeable by Royal Mail to Zipvit, because the invoices stated that the supplies of mail media services were exempt from VAT. In summary, our case is that such invoices cannot satisfy the mandatory requirements of Articles 178 and 6, 9 and 10 of the Principal VAT Directive for several reasons, including the two given by the Court of Appeal. First, to dispense with the invoice requirement in this case would give Zipvit what Lord Justice Henderson accurately called an uncovenanted bonus generated by Zipvit's unilateral decision to treat the amount as being VAT inclusive, contrary to its contractual agreement that they were VAT exclusive. That's the Court of Appeal's first reason. And second, to dispense with the invoice requirement would be contrary to the indispensable purpose of a VAT invoice, which is to allow a tax authority to monitor whether the supplier has accounted for the output tax. And in this case, it is common ground that Royal Mail has paid no VAT to HMRC in relation to these supplies. The starting point of the more substantive analysis is Article 178A of the Directive, Primary Authorities, tab 16, MS 893. Article 178 expressed, as the Court of Appeal and others have noted, in mandatory language. In order to exercise the right of deduction, a taxable person must meet the following conditions. For the purposes of deductions pursuant to Article 168A, that's our case, in respect to the supply of goods or services, he must hold an invoice drawn up in accordance with Articles 220 to 236, 238, 239 and 240. And the relevant one of those articles for present purposes is to be found at tab 19. It's Article 226. MS 97, internal 38. Without prejudice to the particular provisions laid down in this directive, only the following details are required for VAT purposes on invoices issued pursuant to Article 220 and 221. And then for our purposes, the key ones are 9 and 10, the VAT rate applied and the VAT amount payable. So on the face of it, that's all mandatory. And in order for my learned friend to succeed on his invoice appeal, he must be able to identify some authority that says that a taxing authority is obliged to dispense with those mandatory requirements, including, in particular, 9 and 10. And after lunch, I will explain why he cannot. The time we agreed for me to finish was between, I think, 2:15 and 2:30. I hope I can get an extra 5 minutes in light of the 5 minutes extra in the morning, and I'm quite confident I'll be finished by within that time.
Thank you very much. We will resume